Good morning, everyone. The topic for today is Rfbt Part 6, the banking of the Secrecy Law of Truth in the Lending Act. So, what is RA 1405 known as the Bank of the Secrecy Law? On September 9, 1955, the Republic Act Number 1405, otherwise known as an act of prohibiting disclosure of our inquiry into deposit with any banking institution, was approved. This law was enacted to encourage the individuals to deposit their money in the banking instead of hoarding them. Are bankers bound by confidentiality? The bankers are not just custodians of our money in the banks. They are guardians of our privacy. Under the Bank of the Secrecy Law, the bankers are mandated to protect any information about the deposit their respective banks save for what the bank fees or client money are not required to be disclosed. The Republic Act Number 1405 is a very short of concise law. It does not admit many exemptions and inclusion is written mostly in a general way, and there is no specific laws on which bank the fees or a client money is not required to be. What if a bank violates your privacy? The bank secrecy is one of the main features of banking, hence ensuring the privacy and confidentiality of a bank deposit is of their highest priority. Any violation of the said act entails of penalty that is imprisonment for any more than 5 years or meted a fine not exceeding 20,000 pesos or both. Suspicious transaction. The law defines the suspicious of transaction as any transaction with covered institution, regardless of amounts of involved, where there is no underlying legal or trade obligation, purpose, or economic justification, and and that the client is not properly identified, the amount of involved is not commensurate with the business of financial capacity of the client, taking into account although the circumstance may be perceived that the client's transaction is constructed in order to avoid being the subject of reporting of requirement under the Act, that the transaction is in a way related to unlawful activity of offenses that is amount to be, being or has been committed, and finally, any of transaction that similar or analogous to any of the can use a bank for disclosing personal information. A bank may be sued for disclosing any information relative to the personal information of the account. Can use a bank for a breach for confidentiality, as it imbued with public interest and due to the highly sensitive natures of information that they get from their customers. Breach of the confidentiality will result in liability on the part of the bank. Hence, any violation of the said act entails a penalty of imprisonment and fine. What laws protects financial information? There is a laws which protect the financial information in the Philippines. One of the common examples of these laws in the Philippines is the Republic Act Number 1405, or an act of prohibiting disclosure of or inquiry into deposit or with any banking institution and providing penalty therefore, otherwise known as the Bank of the Secrecy Act of the Philippines.
So Section 2 of Bank Secrecy Act, which states that all deposits of whatever nature with banks or banking institutions in the Philippines, including investments and bonds, issued by the government of the Philippines, its political subdivisions, and its instrumentalities are hereby considered as of and absolutely confidential in nature, and may not be examined, inquired, or looked into by any person, government official, bureau, or office, except upon written permission of the depositor, or in any cases of impeachment, or upon order of a competent court in cases of bribery or dereliction of duty of public officials, or in cases where the money deposited invested is the subject matter of the litigation. So it is clear from the wording of the law that any bank is prohibited from disclosing the financial information of any of its clients. So what are the acts prohibited by the Bank Secrecy Act? So Republic Act number 1405, otherwise known as the Bank Secrecy Act, prohibits the disclosure by any bank institution of any information of its clients in connection with his or her deposits therein, including investment bonds. So as stated back, these are deemed absolutely confidential except under the following situations. First, upon written permission of depositor in cases of impeachment, upon order of competent court in cases of bribery or dereliction of duty of public officials, or in cases where the money deposited or invested is the subject matter of the litigation. So Section 3 of the said law also provides it shall be unlawful for any official or employee of a banking institution to disclose to any person other than those mentioned in Section 2 hereof any information concerning said deposits. Hence, the law prohibits the bank from letting any other people know the financial status of its clients. At the same time, it prohibits other persons from acquiring financial information of some other person. So, the exceptions, the law protecting the financial information of an individual is not an absolute rule. So, the law itself provides for its exceptions. As mentioned above, Section 2 thereof stated certain exemptions, meaning deposits can be inquired into if there is a written permission from the depositor himself. Likewise, they can be inquired into in relation to pending cases such as in cases of impeachment or upon order of a competent court in cases of bribery or dereliction of duty of public officials, or in cases where the money deposited or invested is the subject matter of the litigation. So therefore, the law allows the acquiring of financial information upon written information of the depositor, or this can be called a waiver. So the law does not specify a form of waiver, hence, so long as it is written, it would be enough. Are trust accounts covered by this law? So trust accounts is a legal arrangement through which funds or assets are held by a third party, which is the trustee, for the benefit of another party, which is the beneficiary. So RA 1405 covers bank deposits and investments in the government bonds in terms of foreign currency deposits. Republic Act number 6426, the Foreign Currency Deposit Act, similarly asserts that mentioned deposits are of an absolutely confidential in nature. So it enjoys the protection that such information cannot be looked at, inquired about, or examined by any person, government entity, or official office or bureau, whether judicial or administrative or legislative or any other entity, whether public or private. So it is, however, allowed to be disclosed only upon the permission of the deponent himself through a letter. So the law also exempts foreign currency deposits from the attachment, garnishment, or any other order of process of any court. So legislative body, government agency, or any administrative body whatsoever. So speaking of trust accounts, the protection under RA 1405 and RA 6426 extends if these are in the form of investments in government bonds or deposits. So will garnishment of bank deposits violate RA 1405? Bank deposits may be garnished by creditors of the depositor. However, in such case, the same will not be deemed as a violation of the bank secrecy law. This is because the amount of deposit is in fact not disclosed. Moreover, writ of garnishment proceeds from a lawful process and thereafter issued by a competent court. So Republic Act 1405, or the Law on Secrecy of Bank Deposits, protects all deposits in the banks or banking institutions in the Philippines. It treats all deposits in the country as confidential and may not be examined or looked into by any person, government official, bureau, or office. So the law is not absolute as it provides for some exemptions such as depositors give written permission in impeachment cases, in cases of bribery or dereliction of duty of public officials upon order of the court, or in cases where the money deposited or invested as a subject matter of the litigation. So under this law, bankers are mandated to protect any information about the deposits in their respective banks. So this law protects the financial information of a person who deposited any amount of money with any banking institution. So the law recognizes the right of an individual to keep his or her financial information private. So to protect the savers and investors from any lurking harm, bank secrecy law, however, the same law may be used by some people to evade paying tax, committing fraud, and illegal activities. So like other laws and frames of the law, this bank secrecy law has flaws to be tackled with, and most of the time is a topic of financial and political controversy. As the world is advancing, it is about time that there are amendments or changes in said law to be adapted to the world in promoting the weighing the balance of privacy, transparency, safety, and justice.
Good day, everyone. I am Angela May Cordova. I will cover the topic about Truth Lending Act. To begin, Republic Act number 3765 shall be known as the Truth Lending Act. It is the policy of the state to protect its citizens from a lack of awareness of the truth cost of credit to the user by assuring a full disclosure of such cost with a review of preventing the uninformed use of credit to the detriment of the national economy. For the Section 3 of this Act, you'll learn more the meaning of the terms used such as board, credit, finance charge, creditor, and person. As such, stated in the Section 4 of this Act, any creditor shall furnish to each person to whom credit is extended, prior to the consummation of the transaction, a clear statement in writing setting forth to the extent applicable and in accordance with the rules and regulations prescribed by the board. The following information. Number 1. Cash price or delivered price of the property or service to be acquired. Number 2. The amounts, if any, to be credited as down payment and or trade-in. 3. The difference between the amount set forth under clauses 1 and 2. 4. The charges, individually itemized, where are paid or to be paid by such person in connection with the transaction but which are not incident to the extension of credit. Number 5. The total amount to be financed. 6. The finance charge expressed in terms of pesos and centavos. And lastly, the percentage that the finance bears to the total amount to be financed expressed as a simple annual rate on the outstanding unpaid balance of the obligation. Everyone, to better understand this act, unsa man jud ay ang purpose and importance sa Truth Lending Act. Truth Lending Act aims to ensure that you received a clear understandable layout of certain costs and terms. The Truth Lending Act also allows you to easily compare financing costs among different products because it requires lenders to lay out certain terms in a uniform way. The point of the law is to make the risk and cost of borrowing transparent and to protect you from predatory lending. And that is the end of our discussion. I hope you learned something from our presentation about Bank Secrecy and Truth Lending Act. Again, I am Angela May Cordova, and in behalf for my partners for this presentation, Ms. Desiree Joy Gonzaga and Ms. Jessa May Fortaleza, thank you and God bless.